My name is Robert Blecker. I'm a professor emeritus at New York Law School, which is not NYU. Please.
I know I've been there. And so has Joe. Um, so let's just start with the first question, which is if you could tell me everything you think is wrong with the Atkins decision.
Well, it's for one thing, Atkins was based upon a manufactured consensus, a faux consensus, if not a phony consensus. The United States Supreme Court has held that the death penalty is only valid if it doesn't violate the Eighth Amendment. That's correct. And it violates the Eighth Amendment if it violates evolving standards of decency of a maturing society. And it looks for those evolving standards of decency to what it claims are objective criteria. Primarily among them are the legislation of the states, the state legislatures. In Atkins, it held that since 30 states did not execute those who suffered from mental disabilities, therefore there was a consensus against it, and thus it violated the Eighth Amendment. The problem with that kind of analysis is that it manufactures a consensus where there was none. For one thing, as to the question of what constitutes a consensus, we don't know. It's nowhere defined. But it seems to me the closest thing we can come to a consensus of the states is to look at what is required in order to amend the United States Constitution. And there, majorities in 3/4 of the state legislatures must concur to amend the Constitution. Thus, I would interpret a consensus for constitutional purposes as 3/4 of the states. And 30, of course, does not reach that or even come close to it. But there's another way in which the consensus in Atkins was faux, if not phony, and that is if you ask the question differently and ask how many states let me try that again. If you ask the question differently and ask how many states exempt the mentally disabled from its ultimate punishment, whether that's life without parole or the death penalty, you get a very different count, because what you find is that 30 states allow for its ultimate punishment, whether the death penalty or life without parole, to be applied to the mentally disabled. So that hardly shows a consensus against it. Of course, those states that do not capitally punish anybody also do not capitally punish the mentally disabled. So it's really not entirely honest for the majority in Atkins to claim a clear consensus by looking at legislation against executing the mentally disabled. So it was based on a phony, a faux, if not a phony consensus. That's number one. Most importantly, the problem with Atkins is that it announces itself as a categorical prohibition rather than a case-by-case. And that's ironic because United States Supreme Court jurisprudence, spurred on by those who have been against the death penalty and sat in the high court, has required increasingly that there not be categorical death penalties. The United States Supreme Court outlawed a mandatory death penalty. You could never constitutionally specify in advance all but only those who deserve to die. Everything was to be case by case, informed by criteria issued in advance, but case by case. And here in Atkins, instead of looking at it case by case and asking the morally relevant questions of, given the mental disabilities of the particular defendant, did they have moral weight sufficient to exempt that defendant, having committed that crime, from that punishment, case by case? Now, I'm one who readily agrees that the mentally disabled should almost never be executed, should almost never qualify for the death penalty. But almost never is not never. And our commitment to human dignity requires, it seems to me, a case by case rather than a categorical exemption, or qualification. And that's the deepest and most difficult problem with Atkins. Third, I'm sorry, go ahead. You said tell me everything that's wrong with Atkins, so I'm...
Yeah, no, that's great. I just
Paul,
ask you.
Paul, I just want to stop for 1 second, just briefly, while I make an adjustment. I need to.
Am I still shouting?
This is about lighting.
We should finish by this time tomorrow, I would expect.
Sorry.
So when he's through, Robert, I just want to ask you a follow-up question.
Sure.
From what you said.
Are you being disturbed, Joe, by that sound out there, the gardeners? You're okay?
Nothing much you can do. It's in the background.
I can't control it.
Yeah, I know.
It's neighbors' gardeners.
Hang on. Okay. We can continue.
Okay, so Robert, just following from what you just said, could you explain a bit why is it that you think that human dignity demands looking at these on a case-by-case basis?
Yes, I fully agree with the United States Supreme Court majority, as well as many dissenters in other cases, that human dignity is ultimately the issue. And ironically, by categorically exempting the mentally disabled from the ultimate punishment, of course, once again, they are included in the ultimate punishment within states who have life without parole, but by categorically exempting them, you're saying they can never reach a threshold of evil necessary and sufficient for the ultimate punishment of death. Now, let's look at this symmetrically for a moment. And we had the same issue with juveniles and whether 17-year-olds could ever be executed. If a mentally disabled person rushes into a burning building at risk of his or her own life to save children inside, do we say, well, they really suffer from impulse control. They don't understand the full consequences of what they do. They can't assess risks. So while we're very glad that they saved the kids, it really doesn't make much sense to celebrate their heroism as if they had an IQ of 100 or more. Of course not. We should celebrate their goodness. We should celebrate their selflessness. We should celebrate their bravery. That transcends their IQ. Similarly, if mentally disabled people are capable of great good, and they are also capable of great evil. And so by categorically exempting them, you are in fact undermining the human dignity, their human dignity. You're saying they're less than fully good and less than fully evil. And I don't subscribe to either. Aristotle was right. Evil exists in the extremes. And so for me, the morally relevant question as a retributivist is, can someone who is mentally disabled in certain respects constitute ultimate evil? And to me, having A, thought about this a lot, and B, explored it inside prisons and interviewed for thousands of hours those who have been convicted of murder in a whole range of murders, from the very worst of the worst of the worst to the less bad but still guilty of murder, I'm convinced that evil does exist, as Aristotle said, in the extremes, and what it essentially consists of on either extreme is either sadism or cold, heartless, indifferent cruelty. Selfish cruelty is the essence of evil, selfish cruelty. And so you find it in either of the two extremes. The sadistic serial killer, the rapist, torture, murderer, who takes great pleasure in inflicting that kind of unspeakable pain and suffering, and the cold, callous, wanton, cruel killer who sees other people as just specks, and if they're in their way, they're to be killed. That kind of evil is the only thing, ultimately, I think, that deserves the death penalty. And I suspect that that kind of evil can be found in people with IQs that are well less than 100, and are certainly found in IQs of people who are well more than 100. And so it transcends it. And so when you categorically exempt, now to fully, if I haven't yet fully answer your question, if you categorically exempt in advance the mentally disabled, you're saying they can be less than fully evil. If they can be less than fully evil, they're less than fully human.
And have you personally met people with intellectual disabilities that you thought were evil by your definition?
I suspect so. I'm not certain because I did not get their psychiatric evaluations, but I have interviewed people who struck me as really very dull and very, very evil, very vicious. So again, a serial rapist murderer of children who has an IQ of 59 is, in my view, evil, sufficiently so that he deserves society's ultimate punishment. And so, again, I'm sorry, to return to your question of tell me everything that's wrong with Atkins, if it proves anything, it proves too much. Because the majority blithely says, well, these people are guilty and they are properly subject to punishment, just not that punishment, the death penalty. But I think that by doing less, according to Atkins, by doing less than it might, the state does more than it may when it sentences them to life without parole. I can't understand the moral logic that says that we will commit ourselves at this moment, no matter how much you prove to be harmless, no matter how much you may, if it is possible, to become more logical, to control your impulses better than you do now, etc., etc., etc. We are committing ourselves now forever to keep you in prison. We're not going to rethink. We're not going to reevaluate. The same logic that exempts those who are mentally infirm but do not rise to the level of insanity from the death penalty also, in my view, morally exempts them from life without parole. And so the consensus that Atkins found when reconstituted and noticing that 30 states at the time allowed their ultimate punishment to be inflicted upon those who were mentally infirm and were not insane, but were of diminished capacity, hardly warrants the finding as an objective matter that states have now turned their back on punishing, ultimately, the mentally infirm. It's a manufactured consensus. That's another problem, deep problem with Atkins. Yet another problem with Atkins was to locate the decision in the courts, arguably, as against the state legislatures. The dissent, of course, emphasized this. And this is a meta question, not the content, but who has a right to decide. Should this be a decision state by state, or is this a decision appropriately imposed by a single court, the highest court, the United States Supreme Court, on the land uniformly? Now, if one embraces, as I do, that the appropriate criterion is human dignity, Trope v. Dulles, then the next question becomes whether evolving standards of decency, which is what Trope announced and what the court still embraces, whether evolving standards of decency as an objective matter has shown that the United States has turned its face against this. And this is very troubling because that's a correlative problem with Atkins, which it masquerades as objective, that which is really subjective. For one thing, state legislation is the product of subjective considerations and often overtly political considerations. That is, the assumption is that the state legislature is and this is part of the majority in Atkins as well as the dissent. The dissent emphasizes this, so I have a quarrel with both sides on this one, that legislation should count as primary. Well, primary evidence, primary objective evidence of the changed and evolving standards of decency of a maturing society. Well, legislation often lags, not leads, those standards. That is, legislators, for a host of reasons, may feel themselves subject to political pressures that preclude them from changing the law, buoyed by the fact that the law as it exists on the books is rarely enforced or not enforced at all, so they don't need to change it. I mean, that happens in a number of respects in the criminal law, which I've taught for decades. They would change it if they were forced to either embrace it or change it, but they're not either. So they stay on record through the legislation unchanged, at the same time as they watch it rarely, if ever, enforced. So you can't really count legislation as objective primary indicators of the evolving standards of decency. Another problem with Atkins, which is a problem with the United States Supreme Court jurisprudence in the large in this area, is the assumption that standards always evolve in the right direction. And that, look, if you're going to really live by evolving standards of decency, then you die by evolving standards of decency too. I mean, suppose public opinion radically changes. And now we're in a law and order mood, or we're in an anti-X mood, or there are a number of unspeakably horrible juvenile crimes, and now the vast majority of the public supports executing 16-year-olds. Well, the United States Supreme Court has struck that down as unconstitutional, as a violation of the Eighth Amendment. You can execute 18-year-olds, but you can't execute 17-year-olds. Well, but what happens if public opinion radically changes? So if you're really committed to evolving standards of decency, suppose our new standard of decency is, yes, you can execute 16-year-olds, you can execute 14-year-olds. If we knew that that was the evolved standard of decency, would we then say, well, now our concept of the Eighth Amendment has changed? You see, as someone who believes that there do exist certain moral facts, I'm left very uncomfortable with the notion that human dignity is solely determined on the basis of evolving standards of decency, because the public can be swept by emotional storms, and has been and will be. But I'm also concerned with an abolitionist court that assumes that it's a ratchet. That is, that the evolving standard of decency should consist in narrowing and progressively narrowing the death penalty until you eliminate it. The United States Constitution unquestionably contemplated a death penalty. The founders mostly supported one, and they unquestionably contemplated it. You see it in the Constitution, certain procedural protections against due process and capital crimes. Capital crimes is mentioned more than once, and people like James Madison supported the death penalty. That doesn't mean that the Constitution demands it. It does not. But it is unquestionably true that the Constitution and the founding generation contemplated it, the death penalty, and that generation supported it. Another problem with Atkins is that it conflates the Eighth Amendment, which is a prohibition against cruel and unusual punishment, which any right-thinking and feeling person supports that prohibition. It conflates it with due process, which is the Fifth Amendment. That is, the court expresses concerns that, they talked in terms of mental retardation at the time Atkins was decided. That's no longer a term that we're supposed to use. But the court talked in terms of it increasing difficulty in adequately trying and convicting and punishing the mentally retarded because they could not aid sufficiently in their own defense. Those are due process problems. They're not Eighth Amendment problems, and they couch them in terms of it. Therefore, it was cruel and unusual punishment to do so. That doesn't follow. It's just not logical. You may strike down the death penalty for the mentally disabled on the grounds that they simply cannot adequately participate in and help their own defense. But then why are you putting them in prison for life without parole? Because they can't adequately supply their own or cooperate in their own defense also. They made a very valid point, it seems to me, that juries, that it could become mental disability could become a two-edged sword in the penalty phase, because the very criteria that lead us to conclude that a person is less responsible might also lead us to conclude that they're more dangerous. And so future dangerousness, if it is acknowledged as a legitimate criterion in the penalty phase for execution, which I believe it should not be, but it is. I mean, Texas relies on it, and they're wrong, in my view. They're morally wrong. Insofar as future dangerousness counts, then the mentally disabled may well be caught in a two-edged sword, because the very factor that might mitigate their culpability and moral blameworthiness might exacerbate their future dangerousness and lead a jury to see mental disability as an aggravator as well as a mitigator, which more than offsets the mitigating influence of the mental disability. And the majority pointed that out, and they are correct. Oh, but you asked me what's wrong with Atkins, not what's right with Atkins. So I guess I shouldn't point that out.
No, that's fine. Could you just say a bit about why you think future dangerousness shouldn't be considered?
Yes, I'm a retributivist. As a retributivist, I firmly feel certain that some people deserve punishment, and that they deserve punishment proportional to their crime, but really to their criminality, which consists, as the United States Supreme Court has recognized in Edmund, in their moral culpability. Now, future dangerousness does not go to moral culpability. Neither does deterrence. We have the capacity and the responsibility to construct prisons in such a way as to keep us safe, even from our worst predators. The fact that they are dangerous does not give us the right to kill them. It gives us the responsibility to incapacitate them. And so the dissent in Atkins criticizes the majority. Hey, how come you folks never mentioned incapacitation? Well, they never mentioned incapacitation because incapacitation is not one of the penal purposes that gives rise legitimately to the death penalty. It is not in Supreme Court jurisprudence, nor should it be. But incapacitation is directly linked to future dangerousness. So if the Supreme Court is right, and I think they're half right, when they say only retribution and deterrence justifies the death penalty, then incapacitation is not a criterion that can warrant it. But some states use future dangerousness, like Texas, as the ultimate criterion. It's wrong. As a retributivist, to answer your question again slightly differently, as a retributivist, remember, we retributivists are just as committed to limiting punishment to what's deserved as we are to affirming it when it's deserved. And one's future dangerousness is not part of what we legitimately concern ourselves with. For us, the past counts. The past. And so future dangerousness doesn't count. And here's my quarrel with Atkins, but it's also my quarrel with the dissent in Atkins. It's my quarrel with the entire court in Atkins. And that is, deterrence does not justify the death penalty. And the best understanding and expression of that was from the great retributive philosopher Immanuel Kant, who said that if you punish someone, if you consciously inflict pain and suffering on one person in order to affect the behavior of somebody else, which is what deterrence is all about, then you are using him as a means to your ends and not recognizing him as an end in himself. And that violates human dignity. So my quarrel with Atkins, but it's a quarrel with the dissent as well as the majority opinion, is that it justifies, it legitimates, as part of the Supreme Court's death penalty jurisprudence, it legitimates deterrence as a legitimate justification for punishment. I don't think it's a legitimate justification for the death penalty, and I don't think it's a legitimate justification for life without parole. Let's see what else. Oh, subjective versus objective. Finally, my quarrel with Atkins is its conflation of subjective and objective. That is, in calling for objective criteria, and both the majority and the dissent do that, they look to legislation, they look to jury verdicts. That's not objective and public opinion. Those aren't objective, or if they are objectively measuring what? Subjectivity. So there may be objective measurements of subjectivity, but the thing being measured is not objective. It is ultimately subjective. That then gives rise to, again, the most deep and difficult question that the Supreme Court faces, and which Scalia criticizes them for, and Atkins criticizes the majority, which is, are they really substituting their own subjectivity for the people's subjectivity? Or are there such things as moral facts? That is the deepest question involved here. Are there moral facts of the matter? And if there are, can we recognize them? And putatively, one of those moral facts is that a mentally disabled person cannot deserve to die. Now, I don't recognize that as a moral fact. I don't believe that that is a moral fact. But there may be some that do. And if they do, I would prefer that they simply acknowledge it to be what it is to them, which is they have come to recognize the moral fact of the matter. Not that the people of the United States have come to recognize it, but acknowledge it for what it is. And that gives us common ground. That is, we proponents, retributive components of the proponents of the death penalty, which is, yes, there are moral facts. Some people deserve to die, and we have an obligation to execute them. Most people whom we condemn to die do not deserve it, and we have an obligation to convert that punishment. There are moral facts. I readily admit it. But by and large, the Supreme Court ducks the issue and won't acknowledge it, and claims to be objective when they are, in fact, even distorting and masquerading subjective measurements of subjective reality.
So, speaking of objectivity and subjectivity, we've talked about how I have a lot of problems with the way IQs are evaluated. And I think you believe that IQ evaluations are not relevant. That's not the point here. How would you? Is there a way objectively to evaluate whether someone is evil?
Well, when you search for evil and try to correlate the appropriate punishment with it, for me, as I said, based upon thousands of hours over decades of interviewing convicted killers and probing their minds and their backgrounds, etc., I come to the conclusion, the moral conclusion, that evil consists in selfish cruelty. And that, again, it exists at the extremes. So if you find someone who is sadistic, taking pleasure in another's pain, and then manifests that sadism in crimes like torturing innocent victims, especially children, the handicapped, the elderly, you have from the crime itself an objective indication of evil. If you see somebody, I'm thinking of spray shooters whom I've interviewed, guys shot into it, passed by in a van with an AK-47 and shot into a crowd of people because there was one person in that crowd whom they had a beef with. And I'm thinking of two instances. And I asked them, they were separately interviewed, do you ever think about the fact that when you shot these people, they had mothers, they had fathers, they had sisters and brothers, they might have had children, and they were innocent. You had no beef with them, and you were going to kill them for no reason, but except that you saw someone else that was right next to them or near them that you were going to shoot at. Do you ever think about the effect that what you did was having on innocent people? No, not really, they both said, essentially equally. And I said, well, why don't you think about it for a moment? And we're sitting across from a table, and the love between us was palpable. That's sarcasm. And one of them said, SOL, which means shit out of luck. The other one said, shouldn't have gotten in the way of my bullet. That is depraved, indifferent, wanton, cold, callous evil. That's one extreme. On the other extreme, the rapist murderers, the torture killers, the serial killers. This is evil. If they have an IQ of 59, it's still evil. Again, I repeat, if someone with a 59 IQ races into a burning building to save the children, I don't start saying, well, he had deficiencies in logic and impulse control. He couldn't help himself. He just had to race into the building. I don't do that. This is someone who's good. This is goodness. This should be celebrated. This should be rewarded and celebrated the same way. This is evil. This should be punished, condemned and punished. I'm no expert. I know the IQ tests can be manipulated. I also have my own anecdote, which I mentioned to you. I mean, I know it won't occur in the film, but I'll just tell it to you quickly. Before my first IQ test as a child, the parents were informed that their children were about to have a very important test. And I remember my parents saying to me, Rob, you're going to have a test tomorrow in school. Take it seriously. Do your best. And I did, and I'll never forget one section of it. This is before we had 3D and screens and the rest of it. And it said, if this is your right hand, then this is your right hand, 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 or this is your right hand. And I remember it just swirling around in my head. So they called the parents in. And my parents assumed that they were calling all the parents in to discuss the test, that it was an IQ test. It had never been identified as an IQ test, but they inferred correctly that it was. And that they were going over with each person's IQ test with them. So they wanted to arrive early so they didn't have to wait on the long line of parents. They didn't know if they had scheduled them sequentially. So they arrived early, but not that early. My father typically was late. And they looked around and there was no line. It was just they. And they called them in and they said, we've just administered, your son's taken an IQ test. And they said, yes, we assumed that. Why? Is there a problem? And the teacher said, well, I mean, he did very well on a number of the sections, scored very highly, but on one, he tests at an idiot level. That was the very words that came back to me. I was, now, maybe that'll save me in case I commit the worst of the worst of the worst crimes. But I'm an idiot in spatial orientation. There's something wrong. I know it. My sense of direction is horrific. You know, thank heavens for GPSs and Waze. I mean, and God's gift to me. Is that morally relevant? No. Obviously, in my view, it's not morally relevant at all for crime and punishment. And so, you know, I'm cautious because the fact that someone tests, I mean, I'm an idiot in certain ways. I mean, maybe we're all idiots in certain ways, but I'm formally designated as an idiot. I know abolitionists would say he sure is in his views on the death penalty, but leaving that one aside, so I'm cautious about numbers. You know, there's a great irony about your film because its tentative title is Death by Numbers or Death by the Numbers. Which is it? Death by Numbers? Execution. The tentative title of the film is Execution by the Numbers. And of course, implied in that is an opposition to that. that it's wrong to execute by the numbers. And I'm all with you. It is wrong to execute by the numbers. That's a categorical kind of approach, which I'm against. Mental disability, mental retardation, whatever you call it, is a very significant mitigating circumstance. We should almost never execute mentally disabled people. We should almost never put them away with life without parole. But almost never is not never. It's almost never. It's a question of degree. And this is an ancient problem. Anaximenes, the second Western philosopher, Anaximenes, the third Western philosopher, after Thales and Anaximander, held that ultimately differences in kind could be understood as differences in degree. It's more or less. That's what the whole framework should be, the moral framework, more or less. Mental disability should be center focused in the penalty phase. It should count for a lot. It should almost always exempt a defendant from the death penalty, but almost always is not always. A serial rapist, murder, torture killer with an IQ of 59 still deserves to die, ordinarily.
So, in your example of the drive-by spray shooters, so if one of them had tested as intellectually disabled, then is it possible that I'm thinking of Jerome Bowden, whom we've discussed. I think it was Jerome Bowden who, as he knew he was being walked to the electric chair, said to one of the guards, "I'm going to be executed now. Afterward, let's play basketball." So is it possible that those spray shooters, if they had a low IQ, that they really didn't get what you were asking them? Because they couldn't understand the concept of death.
First of all, many of us cling to hope even as we're told that we're dying, and make plans for a time when we know we won't be around. The United States Supreme Court, see, this raises a question again of degree. What is the relationship of mental disability to insanity? Now, in order to be disqualified from any punishment, standardly, you must fail to know or appreciate the nature and consequences of your crime, and or that your crime is wrong, that you don't appreciate right from wrong. In order to be executed, the United States Supreme Court has held, again, you could be disqualified from execution, though you had qualified for it in terms of the crime and your mental state at the time you committed the crime. You would still be disqualified from being executed if you did not know what was about to happen to you, and or due to mental disease or defect, and or you could not connect your crime with your punishment. Now the irony there is, I've written a book, The Death of Punishment, in which I go through this in much greater detail, and I'm sure you're not interested in all of it, and it wouldn't appear in the film anyway. But these guys rarely connect their crime to their punishment. We've set up a whole system, penal system, in which we disconnect crime from punishment. That's the grand irony, which is that what a guy did outside is irrelevant for his lifestyle inside. And that comes not only from the inmates themselves, that comes from the officers. I can't tell you how many of them have told me, corrections officers, what a guy did out there is none of my business. I only care how he behaves once inside. So the grand irony is that those who deserve it most often suffer least in the prison, and those who deserve it least often suffer most. They're most preyed upon even though they committed the least serious crime. So this is a much deeper problem. We have fundamentally disconnected crime from punishment. Fundamentally. And so someone who really didn't understand what he was doing, I want to know that. Selfish cruelty, again, selfish cruelty is the essence of evil. Either the sadistic satisfaction, which I think transcends IQ, taking pleasure in inflicting torturous pain on other human beings has very little to do with IQ. I think it has to do with a predatory instinct. I think there are people who are simply viciously evil. They are instinctively, predatorially violent. And that has nothing to do with IQ and logic.
But what I'm trying to understand is how would you, if you're the judge and jury, how would you find out whether somebody really does understand what they've done and what the consequences are?
Well, for one thing, if I'm the defense attorney, I have them take the stand. Now, part of the problem, again, is the majority is correct in Atkins, which is insofar as future dangerousness counts. It can count against the mentally disabled. So the very necessity to establish the mitigating circumstance might also supply a jury with an aggravating circumstance. So one of the remedies to me is to abolish future dangerousness. There can be no mention of future dangerousness. But let the jury see the defendant. Let the defendant be questioned by both prosecutor and defense attorney. Let them see it. Let them see. Now, you have problems of faking it too. I can't tell you how many guys I've seen rehearse their sobbing before the parole board and their remorse and regret. That's another problem, which the majority points out, and I would expand on in Atkins, which is that the mentally disabled may well not be able to express or show, even if they do in fact feel remorse for what they've done. But that transcends questions of mental disability. There are ethnicities and subcultures within our culture that holds deeply to the notion that manhood is primary and that you're never supposed to say you're sorry or show emotion, even when you feel it. I mean, guys have broken down to me and with me during interviews when it's in a safe space, but once they walk through that door and they go out, they keep a steely demeanor, and you would think by just casual observation, these are guys that don't feel and they're scared, but they won't show it. Partly because survival depends upon it. It's a very difficult question. How do you know? I'm no expert in this. It counts and it should count, but it shouldn't be categorical. I just go back to that. You do your best with obviously some of the ways we have now. You can tell me you're more of an expert than I am, much more than I am. You're a psychologist. I'm not. I think of some other stories about that. I think of one. Unrelated, but just you would get a chuckle out of that. Darrell Holton in the film Robert Blecker Wants Me Dead talked about they gave him a battery of tests to see if he was subject to execution, and one of the questions which made him start laughing is, "Do you believe that somebody's trying to kill you?" He said, "Yeah, sure. The state of Tennessee, it's doing its best." But he knows if he says yes, that's going to count as being paranoid. There are real problems with all of these tests, these so-called objective evaluations. I know that. You try to give the jury their best sense of the person, and then from certain crimes, you can infer that if they are sane, if they pass the threshold test, they didn't think they were squeezing lemons when they were strangling their victims. They didn't think that, they knew that they were raping their victims. They knew they were torturing their victims. They knew they were randomly killing their victims. You can get that sense. Look, Atkins himself, remember, with a 59 IQ, knew that JFK Jr. had just died in a plane crash, that he was the son of the president, could make change, use déjà vu correctly in context. There are a number of other indicia that he understood what was going on. And so if you pass the threshold of sanity, that is, you are aware of the nature and consequences of your crime, and you are aware of right and wrong, then it seems to me we're left with case-by-case other kinds of questions. And one of them comes out of the insanity context too, and it's made brief mention in Atkins, and it deserves more mention, which is the more sophisticated, not the McNaughton insanity test, the earlier classic one, but the revised, the Model Penal Code revision, includes, and you'll see I'm being responsive to your concern centrally, includes, in addition to do you understand the nature and consequences of your conduct and that it's wrong, includes the substantial incapacity to know or appreciate the nature and consequences of your conduct and that it's wrong. Appreciate is something that's very important, a very important word in the insanity context that should also be used in the mental disability context, even the more so. Did you appreciate? It's more than surface knowledge. The example I give in class, 7-year-old Janie pushes 3-year-old Johnny out the window. Why? Because he was playing with my toys. And what'd you think was going to happen? I thought he was going to fall. And then what? I thought he was going to break. And then what? I didn't think he was going to play with my toys anymore. Well, she knows what she's right. He's going to fall, he's going to break, he's going to die, and he's not going to play with her toys anymore. She knows what she did. She knows she killed him. But does she appreciate it? No, of course not. She's going to be on a psychiatrist's couch for most of the rest of her life when she realizes that she killed her brother because he played with her toys, and the ruin that she inflicted on her parents. Well, the word appreciate is very crucial, and it seems to me it's best imported in the mental disability context. We want to find out, and I think I'm being directly responsive to your question, we want to find out not only did he know what he was doing, but did he appreciate what he was doing? Did he appreciate? And if he is mentally disabled in a way that he does not appreciate it, then no, he's not subject to the death penalty. But no, he's not subject to life without parole either. I mean, why is he subject to any punishment? Yes, we have to keep ourselves safe from him if he represents a danger. But why are we punishing him? Why are we inflicting pain and suffering consciously on him? Why aren't we just incapacitating him and keeping ourselves safe? Why do we want to make that setting uncomfortable? And so again, if Atkins proves anything, it proves too much. It not only proves that we can't execute, it proves that we can't punish with life without parole. If we're going to be categorical about it, why are we allowing, again, half the states have abolished the death penalty? Are they allowed to have life without parole for mentally disabled defendants? Right now they are. Why? Why should the ultimate punishment, why should their ultimate punishment include those who are mentally disabled? Because, if one supports it, sometimes mentally disabled defendants deserve society's ultimate sanction.
So when you focus in on this point about did they appreciate what they were doing, I'm not aware of anything much on IQ evaluations that gets at that, and so it seems to me that just like when you're talking about insanity, that's a legal term and it doesn't map one-to-one on what mental health professionals can assess. And I'm not, psychologists have memory tests and same indifference tests and so on. I'm not aware of an appreciation of the consequences test. And so
one can imagine certain questions that you would ask him after you spray shot. After you use your AK-47 to spray, what happens if you kill an innocent person, if you killed innocent people? Do you think anybody cared about them? Do you think that they have brothers and sisters, et cetera, et cetera? You can start getting a sense of, do they understand human connections? And again, if they don't, I mean, here again, it's a double-edged sword, because let's talk about the psychopath. So-called psychopath. A psychopath, at least conventionally, I understand in the psychological literature, a psychopath tends to have no feelings, can be manipulative, forms no real relationships, does not really concern himself with anybody else's emotional well-being. Psychopath maps evil pretty closely in one extreme. It really does. That depraved, cold, callous wantonness. That's one extreme of the evil. The other, again, is the sadist. The psychopath is generally not a sadist. He's generally devoid of feeling. The sadist can be ultimately, can have an orgasm while someone I had the misfortune of seeing on Florida's death row, Danny Rawling, left detailed accounts of his orgasmic experiences as he raped and tortured and beheaded his victims. I mean, ultimate evil, deserved to die. Even the Miami Herald, which was abolitionist, which is and was abolitionist, sort of ran an editorial saying if anybody deserves it, he does when they finally executed him. But anyway, so it's the extremes. So again, I'm driven back to the question. I hope if nothing else appears here, this appears in it. Can mentally disabled be evil? And can they be good? Yes, almost everyone, I hope, would say yes, they can be good. Yes, they can deserve to be celebrated and rewarded. But then if they can be good, they can be evil. And they can deserve to be punished. I mean, that's the bottom line. And that's the problem with Atkins. It just categorically dismisses them. This comes up, by the way, one more thing I should mention. In terms of, in the criminal law, can the mentally disabled consent to having sex? Or do you necessarily commit rape if you have what appears to be consensual intercourse with someone who is mentally disabled? And it's a difficult question, because insofar as you say, no, you're necessarily raping her, if you're aware that her IQ is 60, she can't consent. Well, then you're saying that she's less than human, less than fully human, because she's not capable of consenting. She's not capable. Well, that's very dangerous and difficult, it seems to me, and troubling. And that's part of what Atkins is saying, which is they're not fully human, at least when it comes to the death penalty. But then again, life without parole, then suddenly they are fully human? Where is it? By doing less than they might, they do more than they may.
Great. I want to go back for a minute to when you were talking about if the Supreme Court saying, well, it's the legislatures that should decide. Given that Atkins essentially said the legislature should decide not whether or not to execute people with mental retardation, but how that's going to be determined, whether or not the person has mental retardation. Is there, and I'm not a lawyer, is there any equal protection issue, given that in some states a given person is going to meet the criteria for intellectual disability, and in other states they're not?
That's one of the oddities of Atkins, because on the one hand, it seems to impose a constitutionally mandated uniform standard. The Eighth Amendment categorically prohibits executing the mentally disabled. Then it backtracks and gives a nod to federalism. Categorically, we're prohibiting the execution of the mentally disabled, but we're leaving it on a state-by-state basis to determine who is mentally disabled. So one can argue that they surrender the very thing that they seem to capture in the opinion. Now, you ask, is there an equal protection problem? The founders understood and agreed to this constitutional plan, which includes the Eighth Amendment. And in doing so, it was understood and universally agreed, and I think by anyone who cares about keeping the plan intact, that state sovereignty primarily consists in the definition, detection, prosecution, and punishment of crime. It also consists primarily, in addition to the criminal law, in family law and property law, domestic relations and property law. That's the essence, the core of state sovereignty. And the deal we made was that different ethos would prevail in different states. And so the criminal law would reflect that different ethos. For example, self-defense. One state recognizes that if you are reasonably mistaken and you come to the defense of another person who could not legitimately come to his own defense because it's really a mugger and the police are trying to arrest him, and you mistakenly believe that the police officer is the mugger instead of the mugger being the mugger, you're reasonably mistaken and you kill the police officer, you haven't committed a crime. Another state does not recognize reasonable mistake. You got to be right in order to come to the defense of others, or self-defense. Do they have a right? You might argue, well, equal protection. If you happen to be in one state, you're a murderer. If you're in the other state and you get self-defense, self-defense is a justification. It means you have committed no crime. So one state defines you as a murderer, the worst of all criminals. The other defines you as not a criminal at all. Is that a violation of equal protection? No. as long as the state treats everybody equally within those confines. Now, there are limits, constitutional limits to what a state can do. In one of the cases, Robinson versus California, that the majority in Atkins cites, the Eighth Amendment, the United States Supreme Court has held correctly, requires proportionality. That is to say, the punishment must fit the crime. And so the Eighth Amendment, there are two views on the Eighth Amendment. One is that the only thing it outlaws are certain punishments themselves, cruel and unusual, the torture. The other is, as the United States Supreme Court said, even 1 day in prison for having a common cold would constitute cruel and unusual punishment. Now, 1 day in prison is not in and of itself cruel and unusual, but 1 day in prison for having a common cold is cruel and unusual. So the second notion of proportionality is that the punishment must fit the crime. And at a certain gross level, if it does not, then the United States Supreme Court properly steps in and says to a state, that's too far. While we respect the diversity and the notion that states are allowed to experiment and reflect their differing value systems and translate them into definitions of crime and punishment, there are limits beyond which you can't go, in which we can objectively say, life in prison, let's leave aside the death penalty for a moment, life in prison for petty theft is disproportionate. Life in prison may be legitimate for some crimes, for murder, but life imprisonment for petty theft is not legitimate, even though the people of your state got really pissed off that people were breaking into cars, et cetera, and stealing radios. Petty theft, you reflecting the popular will, instituted a new penal law that held life imprisonment for that. No, you can't do it. You can't do it. State diversity can go only so far. There have to be a certain core common set of values that constitute the limits to what the Eighth Amendment will tolerate. And so at once we allow for and celebrate diversity state by state, especially in the criminal law. The essence of state sovereignty consists in the definition, detection, prosecution, and punishment for crime. And yet there are limits beyond which a state may not go.
What do you think about the fact that, should anything be done about the fact that, with respect specifically to somebody with an intellectual disability or possibly has one, that if tried in one state would qualify for execution, but in another state, no?
At a certain lower limit, the Constitution prohibits it. Even the dissent in Atkins, when trying to narrow the exemption of the death penalty for mental disability, acknowledges, even taking an originalist position, that in 1791, so-called idiots were exempted from prosecution and punishment. So there is a lower threshold in which, without identifying it as objective moral fact, the Eighth Amendment outlaws any punishment. And then the next question that follows from that is, are there objective limits where punishment is permitted, but only to a certain level and not beyond it? And that gets me back to, how can someone who's mentally disabled be given a punishment of life without parole? Tell me the logic by which he is sufficiently morally culpable so that we're willing to commit forever, never to rethink it and release him, and yet we're not willing to execute him. I don't get it. But yes, the answer to your question is yes, there are limits beyond which a state cannot constitutionally go. And again, the example that they gave in Robinson v. California. By the way, in Robinson v. California, California made it a crime. Actually, this is relevant. California made it a crime to be an addict. And the Supreme Court held, arguably, that you cannot make it a crime to be anything. You can only make it a crime to do something. Now, if what you do is a function of who you are, if you are internally compelled to do it because you are X, then aren't they punishing you for status under a different name? And so that if the majority is right, that mentally disabled people, and they sweep too categorically, but there probably are some mentally disabled people who are overcome by an irresistible impulse to kill. They are sick, and that's, again, another way of expressing the deepest question of this whole discussion. Can you be sick and evil at the same time? Standard definitions of insanity, although the model penal code does, but the standard definitions in many of the states do not allow for irresistible impulses to count. They only allow for cognitive standards. Are you aware of what you're doing? Or even better, in my view, do you know and appreciate the nature and consequences of your conduct? And do you understand the difference between right and wrong? Can you perceive that some things are right and some things are wrong? And very dull, normal people in terms of intellectual acuity can ordinarily perceive the difference between right and wrong. They do know what they do, and then the key question is, do they appreciate it?
So, I'm still stuck on this, the states having different standards.
Oh, okay. We'll turn.
I know you said, you're not a psychologist and so on, but given that different states have had different standards, like you probably know, Georgia is the only state that says you have to be proven beyond a reasonable doubt to have an intellectual disability, in order to come under the Atkins ruling, and no other state has that. And given you familiar with the Bresenio factors, how they were used in Texas?
No.
Oh, well, somebody made a list of factors, I guess it was the legislature, made a list of factors that supposedly characterized somebody with an intellectual disability, but they were based pretty much on the stereotype, like Lenny, from
Right.
Tyson. And the U.S. Supreme Court, I think it was Moore versus Texas, ruled that you can't use those Bresenio factors anymore. So, but while they were allowed, as you say, Texas wants to execute everybody.
No, I didn't say that. I said Texas uses future dangerousness as a crucial factor, and I think they're wrong.
Yeah, okay.
But I want to address that about the burden of persuasion before I forget it. Can I? You said Georgia alone. I didn't know that, but you say Georgia alone requires proof beyond a reasonable doubt of mental disability. And should a uniform, if you're holding uniformly that the Eighth Amendment outlaws executing the mentally disabled, don't you fundamentally undermine that very decision by allowing a state-by-state basis for what constitutes mental disability, A, and B, for what constitutes adequate proof of mental disability? And burdens of persuasion are really very difficult. Now, at one level, the United States Supreme Court has mandated proof beyond a reasonable doubt of every fact necessary to constitute the crime charged. The state has that obligation. The United States Constitution, the Supreme Court has held, commands proof beyond a reasonable doubt of every fact necessary to constitute the crime. So if mental disability is a fact that negates what is sufficient to execute, then even raising a reasonable doubt about it should be sufficient to disqualify execution, in which case Georgia's standard would be unconstitutional. Burdens of persuasion are quite crucial, and in my view, one of the huge mistakes of Supreme Court jurisprudence is to tolerate constitutionally the same burden of persuasion in the penalty phase, where the question is life or death, that it allows constitutionally in the guilt phase, where the question is, did he or she do it? The question of the guilt phase is, did he do it? The question of the penalty phase is, does he deserve it? Now, that's the latter, the penalty question of life or death, is partly a moral question, and the Supreme Court seems to understand that, but they don't take it the step further that I think they should, which is that there should be a different burden of persuasion at the penalty phase than there is at the guilt phase. Proof beyond a reasonable doubt is all that should be required to find and convict murder. Proof beyond a reasonable doubt of the facts that constitute the murder. But at the penalty phase, I think there should be a higher burden of persuasion, and it should be twofold. One is, if you have any lingering doubt or residual doubt of the guilt of the defendant of first-degree murder, then you should not find death. So it's a higher standard than reasonable doubt. In other words, if you have a doubt for which you cannot give a reason, but it's there, I'm just not sure. I can't tell you why I'm not sure, the juror says. I can't tell you why. I can't give you a rational reason why I'm not sure that this is the guy that did it. Then you don't find death. But that's only half of what it should be. So the United States Supreme Court has refused lingering doubt or residual doubt as a constitutional mandate. But the second part of the standard that I urge is you should not only be convinced beyond a reasonable doubt, that is, with no lingering doubt, no residual doubt that he did it, you should also have to be convinced the jury should be instructed to a moral certainty that he deserves it. To a moral certainty that he deserves it. Now, when you see somebody with a mental disability, it's very difficult to have that moral certainty that he deserves it. You will almost never meet that standard. But again, almost never is not never. It shouldn't be categorical. It should be case by case, which reflects and respects the humanity of the individual defendant. So, again, George, would I strike down a burden of persuasion as inconsistent with the spirit of Atkins, which put the burden of persuasion on the defendant to prove beyond a reasonable doubt that he was mentally disabled? I sure would strike that down as being inconsistent with Atkins. Even if I disagree with Atkins, I would strike it down as inconsistent with Atkins, fundamentally inconsistent with the spirit of Atkins. So I do fundamentally hold that it's for the states to define, detect, prosecute, and punish crime. But once the United States Supreme Court finds that the Eighth Amendment mandates a uniform standard of not ever executing the mentally disabled, I would not allow a state to put the burden of persuasion on the defendant to prove beyond a reasonable doubt that he in fact qualifies as mentally disabled so as to exempt him from execution. I think that fundamentally violates the spirit of Atkins. By the way, Paula, I'm relying on you because, again, if you take my statements out of context, you can make me into a fellow abolitionist. I mean, because I'm being critical of Atkins. I mean, I'm being critical of both. I'm trying to give you an honest analysis, but right. And that case by case. It's right, and can be good, and because the one implies the other.
You've made that point beautifully.
And can be heroes. I guess, did I say that? If some people with mental disabilities can be heroes, other people with mental disabilities can be villains. They're just two sides of the same coin. Mentally disabled people can be capable of greatly heroic acts, and they can be capable of deeply vicious acts. They should be rewarded and celebrated for their heroism. They should be punished for their villainy.
And do you think that the same person with an intellectual disability who risks their life to save children from a burning building because they care is also going to be capable of evil? Or is the fact that they care going to tell you that, well, this is not somebody who would be sadistic or cold-hearted and remorseless?
Well, I mean, can one and the same person, this transcends the question of mental disability, can one and the same person do great and good acts sometimes and vicious acts other times? Well, yes. They can. I have ample evidence of that. Some of the guys I've interviewed who were some really vicious killers did take pity locally and engaged in charitable behavior with the down and out. Some of them, if you probe their morality, you find that there's an instrumental support for it, which is they wanted to be protected. If the police came around, people would warn them. But I have found people who are genuinely capable of charitable acts, who in other contexts are genuinely capable of despicable acts. The penalty phase is supposed to be an occasion for the jury to balance that. You're supposed to look at the defendant, the person. He's no longer the defendant. At this point, he's a convicted first-degree murderer when you get to the penalty phase. And you're supposed to ask questions of, well, what were the influences on his life? Was he beaten and abused as a child? And if he was, then you're going to have some greater sympathy for him. Is he mentally disabled? If he is, you're going to have some greater sympathy, again, for him. And you're supposed to engage in this ultimately difficult balance. Intuitive. Truth comes partially intuitively. I trust more the intuition of juries than I do psychological tests by the numbers. I'm with you. We masquerade as somehow objective truth tests because they allow us to calculate to 5 decimal places how many standard deviations away from this, in this particular characteristic, this person is from the general populace. The fact that we can, Lawrence Tribe did a brilliant piece many years ago that called Trial by Mathematics. It was in the Harvard Law Review. And what he says, this could be ultimately very useful for you. What he says, and by the way, when I had occasion to introduce him recently in a public forum, I reminded the audience of this because it's become largely lost. Tribe talks about, quote, the dwarfing of soft variables, which is to say that we have so much respect for numbers that we tend to count and count more that which we can calculate numerically, and we tend to undercount that which is intuitive and variable, soft variables. Undercounting soft variables. He's absolutely right. Tribe is absolutely right about that. And so I would like to see us count more and more soft variables. I would like us to rely in a deeper and deeper sense on jury's intuition. I want the convicted killer to be able to take the stand, not worried about arguments of future dangerousness, which I would not constitutionally allow in the court, or at the very least before the jury. If I wouldn't constitutionally allow it, certainly as a legislature, I would abolish it. Again, as a retributivist, A, the past counts, and B, retribution is as much a limit on punishment as it is an affirmation for it. We are just as committed to making sure that those who do not deserve it do not get executed. And too many people have been condemned to die who didn't deserve it because the criteria for death penalty has been way too broad.
Fabulous. Okay, so you went way down in the material that you sent last night.
Yeah, we've done a lot of it, haven't we?
You've done, yes, almost all of it. Under the category of what are the solutions to these problems, you did talk about adopt a higher burden of persuasion in the penalty phase and abolish capital felony murder.
Yes. Robbery murder has put more people on death row than any other. I mean, if we talk about Atkins, that was a robbery murder. By the way, another problem I have, Atkins was rightly decided in the sense that Atkins himself would not have qualified for the death penalty under the burden of persuasion that I'm urging. For one thing, there is definitely residual doubt. I think there's even reasonable doubt, but there's definitely residual doubt as to whether he or his co-defendant actually committed the murder. And secondly, it was not the worst of the worst of the worst. The United States Supreme Court has rightly held And we've been committed as a society since, I think, 1794, when Pennsylvania enacted the first-degree murder statute. We've been committed to reserving the death penalty, and I think we should rightly also be committed to reserving life without parole. I mean, we could have the same discussion if the death penalty were completely abolished. Now we would still be troubled, and rightfully troubled, with how are we committing mentally disabled people to a life with no possibility of parole. But leaving that aside for the moment, we've always reserved the death penalty for the worst of the worst. We rightfully reserve it for the worst of the worst of the worst. Felony murder in the original Pennsylvania statute, which has been copied by most of the jurisdictions that have the death penalty, qualify a person. That is, if you kill in the course of if you intentionally kill in the course of an in furtherance of a felony, you thereby can qualify for the death penalty. That's wrong. That is, the assumption is that those who rob and then kill are killing from a pecuniary motive. Now, I would include that as one of the aggravating circumstances, the hired killer, the person who has his parents killed in order to collect life insurance. I mean, this is depravity. This is evil, right? But the robbery gone bad that results in a killing, I know of so many instances from my years inside prisons interviewing convicted killers and probing their crimes and their minds and their backgrounds. So many instances of robberies that went bad. The robbery was done from a pecuniary motive. The killing wasn't done from a pecuniary motive. And so when you have robbery, felony murder, which is the most common one, my view is you've morally expanded the death penalty beyond where it should go, way beyond. Rape should continue to qualify, not because it's a felony, rape, murder, not because it's a felony, but because it's torture. And torture is the aggravator. There really needs to be only one aggravating circumstance, in my view, and that is especially heinous, atrocious, and cruel, which is not an aggravator that can ever be quantified, but is an aggravator that can be qualified. It's all and should be more or less. This whole process should not only be intuitive, it should be analog, it shouldn't be digital. Numbers make it digital, these hard quantifications. That's wrong. That's not what this is about. This is about degree. This is all about degree, not kind, degree. And at some point, you have to be willing to say that wherever you draw the line, and this is one of the difficulties, but this is a difficulty in law itself, wherever you draw any line, two instances that fall just on either side of the line will be fundamentally similar and yet treated differently, because they happen to fall just on other side of the line. But that's what law is. It's imposing discrete categories on life, which is an otherwise continuous situation. And if you can't tolerate that you're going to treat instances that happen to just fall at the boundaries on opposite sides, you're going to treat them differently, even though they're virtually indistinguishable, you can't tolerate law. Because that's what law is. Discrete categories imposed on life's continuum.
Great. And you had a sentence in something that you had written.
Hang on one second.
This is squeaking, Joe? Is that it?
No. Just changing in the background. Hang on.
We're getting close to the end.
Okay. I think we covered a fair amount here.
Oh yeah. There's this one thing about Joe's work in it. The sentence here that you had written is irony, and then you said you've talked about this, but I just love the way you said this. Death penalty jurisprudence demands a particularized judgment.
Oh, yes.
I love that.
Yes. Okay. By the way, before we quit, I'm not forcing it, obviously. My sense is if we talk about Amy Coney Barrett, it could be useful to you. It'll never appear in the movie, but it could be useful to you.
No, I already made the note.
Oh, okay.
And Larry Trotter.
Oh, he's been, I've had two people who have been extraordinarily helpful in my professional life, and Larry's one of them. And Philip Hyman, who started me on my prison journey, is the other. Those are the two people. But as I say, I should show you the blurb from the book, The Death of Punishment, and that's coming from Tribe, from an abolitionist. I will show it to you, in fact.
Did you know Paul Freund, by the way?
I did. I had constitutional law with him.
When I was an undergraduate, he taught an undergraduate course in constitutional law, and I took it, and I got an A.
Oh, good. You did better than I did.
I loved him, and you'll appreciate this. I grew up in Springfield, Missouri. He was from St. Louis, and I think he never married, right? He was.
Yeah, I think not.
My grandmother, my mother's mother, at Rosh Hashanah, she always used to make teglach. You know what those are?
Yes.
Okay, she used to make teglach. She sent me teglach from Springfield, Missouri, up to Cambridge, and she knew, and her son, my uncle, had just, in his 30s, started law school at a time when people were saying, that's weird, he's so old to be going to law school. And anyway, so she had all this great feeling, for Jewish lawyers, right? So she sent me a box of teglach, and she with a note saying, give some to that nice Professor Fine. I don't remember if I did or not. And sometime, remind me to tell you about why I interviewed Lawrence Tribe for an article I was writing.
Wait a minute. Now, where do you want? I want to reread what I said.
Please do, yeah.
Where do I say it? What I haven't. I'm dealing with what I sent you this yesterday, but I'll still find it. Irony, huh? How do I put it?
It says, irony, death penalty jurisprudence demands a particularized judgment. Because I just think that
Yes.
so much of what this is about is that, do they have an IQ? What's their number compared to somebody else, and all of that stuff, and so much of what you said that just encapsulates that. You want me to see if I can find it in what you sent me last night?
Here it is. Particularized judgment, yet the abolitionist court inclines to categorical restrictions. It's on my page 11 of what I sent you yesterday.
So Joe,
Still rolling.
I didn't know if you were ready yet. Okay.
Oh, yeah.
Okay, Robert, over to you.
It's ironic that as you survey death penalty jurisprudence over the past decades, increasingly it demands a particularized consideration of each individual human being as a human being. And yet, Atkins and its progeny are purely categorical, which seems to cut just the opposite way. Case by case, person by person, human being by human being.
Great. And I think, is it accurate to an accurate understanding of part of what you're saying to say that and I think I started to say this earlier, that just as the court's need or request for an answer to is this person insane doesn't map one-to-one on what therapists do to a large extent. I think in a way even more in the case of intellectual disability.
Good. Yes, I can say that. I know just what you're looking for.
Okay, go ahead.
Obviously, the question of mental disability and insanity are deeply and closely related. And the courts have held, and rightfully so, that the ultimate question of sanity or insanity, responsibility or not, is not for the psychiatrist or psychologist to make. It is a legal question. It is not a psychological question. The expert witness can talk about the symptoms and the manifestations, but the expert witness can never give as a conclusion, this person is insane, this person is not responsible. That's a question for the jury. That is not a question for the expert. Similarly, it seems to me, the question of whether this person is mentally disabled may be a question for the expert, But what is not a question for the expert is whether this mental disability is morally relevant so as to exempt or permit punishment. Is that what you want?
Yeah, yeah, and you know, part of me thinks that a solution would be forget about IQ evaluations and develop questions that get at things like, did the person really understand what were going to be the consequences?
Appreciate.
Right.
Appreciate more than surface understanding. Well, and I guess I would say one more thing at least, and then let's talk about Amy Coney Barrett. When I say I feel certain that some people do deserve to die, that's a very carefully chosen phrase, feel certain, because it has both an emotive and a cognitive component. The certainty is cognitive, but the feeling is emotive. Informed emotion should count. Intuition should count. Numbers can never capture that. Can never capture the intuition adequately, can never capture the emotion, which is why the ultimate question in the penalty phase is not an empirical one. It's an emotional one. It's a moral one. And Adam Smith, in his theory of moral sentiments, by far the greater work than The Wealth of Nations, for which he is more famous today, but was not in his own time. Adam Smith said that every moral question is ultimately emotional. So emotion should play a crucial role. Informed emotion. We rely on the experts to help inform us. Help. But ultimately, the experts do not have the emotional root or expertise to allow the jury to make that informed, emotional, intuitive decision.
So I'm thinking that when it comes to intellectual disability, there are so many points along the way from the time someone's picked up by the cops and taken in for questioning, right through to the penalty phase, where there are questions that an IQ test couldn't necessarily answer, like, did Jerome Bowden understand that he should have called a lawyer instead of letting the cops question him for 3 straight days alone? Or you know, to questions that have to do with signing false confessions and being easily led into committing a crime or into signing.
You're out of my area of expertise. I know what you want. I can't give it to you. I don't have any confidence. I've only talked about that which I'm confident.
Okay.
I just simply do.
I'd love to talk to you sometime because I've talked to my congressman Jamie Raskin, who's working on the sort of addendum or whatever to the 25th Amendment about fitness to be president, and he's wanting to bring in psychiatrists, and I'm saying no, you'll get dueling psychiatrists. You know, that's not a science. But find out if the president knows what's in the Constitution. Find out if the president understands cause and effect. Find out if they're having memory problems. You know, that's.
May I ask you, should our members of Congress know what's in the Constitution? Because AOC, when asked to name the three branches of government, said, let's see, the Senate, the House, and the President. So this is the leader now, the emerging leader of the left wing of the Democratic Party, who could not even name the judiciary as one of the three branches of government.
That's
I mean, I hate to bring up embarrassing facts, but you talk about facts.
That's pretty awful.
Yeah, isn't it?
But I would love to talk to you sometime when we're not filming about what kinds of evaluations are needed to that are relevant from the time that the police pick you up right through the penalty phase. What really is relevant, given that a lot of what's
I would like to see as much as possible videotaped, including when it's fresh, and then give those tapes to both sides and let them find what they think is morally significant. There should be conversations, many, many hours of conversations. And again, both sides should have all of it, access to all of it. And then you will have dueling presentations of who this person is. And then let the jury decide. Now, again, the crime can, to a great degree, manifest the evil. Whereas in Atkins, I mean, it's terrible that they killed this innocent guy. It's horrible. It's murder, and it is murder. But it doesn't manifest the kind of evil that we should be responding to with the death penalty. So even if he was the one who shot, and well, I guess we don't want to go into it, but in terms of crime scene photos, which are distorting, and that's a problem too. But that's not, I guess, relevant. You want to talk about Amy Coney Barrett?
Yeah, let me just really quickly look through the rest of the notes.
Has my tie been off all this time? I mean,
That's casual.
it's cockeyed, but
Whatever.
so be it.
I didn't notice it myself.
Well,
Nobody's going to be looking at your tie, Rob.
I know, nor should they be. I'm just envisioning my wife saying, "Why'd you have to look like a mess?"
If they notice your tie, we've all fucked up.
That very good. Please put that in the movie.
Let's see, are you just, okay, okay, I had a couple of questions here. Maybe we've covered this. How do you determine guilt beyond a shadow of a doubt in the accused, if the accused has impaired memory, impaired understanding of cause and effect, and of the meaning of the trial?
Well, first of all, you don't determine guilt beyond a shadow of a doubt. You determine guilt beyond a reasonable doubt. My claim is that in the penalty phase, unlike the guilt phase, the question is, did he do it? And there you have to be convinced only beyond a reasonable doubt. By the way, proof beyond a reasonable doubt is often seen as the great bulwark and innovation for defense, for the defense. The irony is that proof beyond a reasonable doubt was a pro-prosecution move, because the standard of persuasion that it replaced was the biblical any doubt rule. In the Old Testament, if it is true and certain of these things have happened in Israel, if there's any doubt, you're entitled to an acquittal. And then in the Boston Massacre trial, the argument was, no, not any doubt won't do, only a reasonable doubt should result in acquittal. So proof beyond a reasonable doubt actually was a pro-prosecution move in its infancy, since it replaced a burden of persuasion that was even higher, which is closer to what I want in the penalty phase. So it's proof beyond a reasonable doubt as to guilt, but it's proof with no residual doubt, no lingering doubt, doubt for which you cannot give a reason but is real. It is not rational, but it's real. The image and metaphor I've used is the relationship of the real numbers to the rational numbers. That is, the real numbers are incommensurably richer than the rational numbers. They include pi, the square root of 2, but they're not rational. You cannot divide any one number by another and produce pi or the square root of 2. There is no ratio. There is no, but it's real. Similarly, there is doubt that is real but not rational. Just like there's conviction, it's emotional in part, or it's lingering. You cannot, it's subconscious. You cannot give a reason, but it's real. That should count in the penalty phase. It should not count in the guilt phase.
Okay, so a couple things. You had said, I want to make sure I understand this. You had said earlier in the penalty phase, you might just have a feeling, you can't put your finger on why and so on. And so I was going to ask you, well then why did you vote for guilt? Because you don't get to the penalty phase, right? Unless there's
And the answer now should be clear. You voted for guilt because you had no reasonable doubt that he did it. But you don't vote for death because you have real doubts for which you cannot give a reason. But they're real. They're lingering doubts. They're residual doubts. You can't give the reason. There's just, I'm sorry, that was one, remember? And the other is you should not only be convinced with no lingering or residual doubt that he did it, you should also have to be convinced to a moral certainty that he deserves it.
So the lingering doubt that you can't put your finger on it has to do with the morality
No,
question?
it doesn't need to. There's just something in this case that I'm just not absolutely sure. I'm sure enough to convict, but I'm just not sure enough to kill. I'm not sure enough to kill. There's something in me that is not certain. Remember, it's not proof. That's why I went through that story with you. The burden of persuasion of proof beyond a reasonable doubt, which is constitutionally mandated, historically replaced an even higher burden of persuasion, proof to a certainty. And the innovation said, you don't need to be certain because we're not certain. Look, I'm not certain that the bridge that I drive over will hold me, right? It is possible it will collapse and kill me and my loved ones. I still drive over it without absolute certainty because I have sufficient certainty. It's close enough. I have no reasonable doubt. I actually have no lingering doubt either, so maybe that's not the best example, but the point still remains I'm not absolutely certain. So I will trust my life and the lives of those I love frequently. When I cross the street, I cross at a green light and I don't see traffic coming. Well, someone could turn the curb and then accelerate and kill me. We all take certain risks with our own lives and the lives of the children that we adore and grandchildren that we adore. They're risks that we think are worth taking, that are rational to take because they are so infinitesimally small. So it can't be really literally proof to an absolute certainty because, as I play the game with my grandchildren, I tell them that they're having a dream right now and that this whole conversation that we're having is not real, that they're dreaming this, and they're going to wake up tomorrow morning and they're going to say, Papa, I had this weird dream in which you were telling me that I was dreaming. And they say, no, this is real. And I say, how do you know that it's real? And of course, you can't prove it that it's real, that this is not a dream. But I am as convinced about certain things as I am that my hand has 5 fingers. I feel them as I hit them. But no one can ever be convinced literally to an absolute certainty without something called faith or something like that. So it requires an emotional component. But guilt phase is beyond a reasonable doubt. Otherwise, it can't function. Nobody will be guilty of anything, and in which case society is in deep trouble on a number of levels. But with the death penalty, and in my view, with life without parole, by the way, because I think the two are very closely aligned, I would have a separate penalty phase for life without parole, which no state has, to the best of my knowledge. In those states that have abolished the death penalty, and all 50 states now have life without parole. So in nearly half the United States of America, we have no death penalty, but in all states we have life without parole. I would require a separate penalty phase for life without parole. And I would require that you have no residual doubt. Now, you'd still have life, but you wouldn't have life without parole, which means we don't reconsider the sentence, ever, no matter what, no matter how you change, no matter who you become. We're so fundamentally committed that you've committed such an act of viciousness and evil that no matter how you grow, mature, or anything, we are committed to punish you forever and cage you forever. That's an awful heavy declaration to make. And if you're going to make it, it seems to me you better be convinced that this person deserves it, because a lot of people have gotten life without parole who don't deserve it.
So I have just one more question, and I would love, because it's already 3 o'clock. And
Wow.
I know to get B-roll and Joe has to clear everything up. I would love to talk about the Amy Coney Barrett another time.
Oh, okay.
Thank you. But I have just one last question, and this is a gut feeling question. Do you have any sense of what percentage of people with intellectual disability who are...
I'm not going to be of any help to you here.
Okay.
You're talking about statistically across the United States? No, I have no sense.
Do you think, I get the impression you think it's pretty rare that somebody, you've said this, I think, in so many words, most people with intellectual disability shouldn't be executed.
Most people who commit murder shouldn't be executed. A fortiori, most mentally disabled murderers shouldn't be executed. It is a mental disability should act as a very weighty mitigator. Almost never should we execute a mentally disabled convicted first-degree murderer. But almost never is not never. It's almost never. Case by case, person by person.
And have you personally either met or known of somebody with an intellectual disability who was sentenced to death that you thought, yep, they deserved it?
No, because most of the people, although some of the people I interviewed, well, I've interviewed people on, wait, let me think. Am I saying no too easily? Most of my time was spent in Lorton, where D.C. didn't have the death penalty, although many of the guys I interviewed had been on death row from times when they did have the death penalty or the federal death penalty. In Tennessee, Illinois, and Oklahoma, well, Darrell Holton was brilliant. See, the vast majority of people I interviewed were not been on death row. I mean, in D.C., a few of them were, but most of them were not. They were serving life sentences, many of them, most of them, but were not condemned killers.
Anybody you've heard about?
I'm sorry?
Or anyone you've heard about? Any cases?
I'm no use to you. At least it's either I'm tired or
No, that's okay.
it's just no.
You were just fabulous, and I'm so grateful to you for doing this. And let's talk about Amy Coney Barrett. I know you're really busy, so you let me know when you want to do that, okay?
You let me know if you think it's relevant. I just thought it would be a useful promo thing for you to have. It wouldn't end up in the film, and just to have someone talking about it as if as part of your trailer, promo, whatever it is. It would just jog people. That's why I would do it now. But I'll let you know if you want to do it at some future time and I'm around. We'll do it.
Well, I mean, how long could that take?
I only think it would take a minute or two. That's why I would do it.
All right, let's do it now.
I mean, just so we have it, because we have Joe set up everything. So you want to ask a question, or you want me to just talk?
No, just talk.
Well, so Amy Coney Barrett has been nominated as the next Supreme Court justice to replace Ruth Bader Ginsburg. And she's known, of course, as a conservative, reliably consistent conservative. But should she be confirmed, well, if you're using it, you're probably using it because she has been confirmed, or maybe not, she will not upset the balance. She will almost certainly, bordering on absolute certainly, reaffirm Adkins should it come up before the United States Supreme Court. She wrote an article in 1998 that was a law review article that was published in, I believe, Marquette Law Review, in which she said that any truly devout practicing Catholic judge faces a problem with the death penalty because that person would be and should be against the death penalty according to church teachings, and indicates that she is. And could rightfully disqualify herself or himself as a sitting judge, could never, as a devout Catholic, sentence anybody to death. Remember, the judge actually sentences. The jury essentially recommends death, and then the judge just follows the jury's recommendation almost always. But no practicing devout Catholic could do that, she said. Should not participate in a capital trial. And she left it open and said it was problematic. I quote, whether they may affirm lower court orders is a most difficult question to resolve. She said that in 1998. She was confirmed, of course, and sits on the Seventh Circuit. And most recently, as a Seventh Circuit judge, she voted with her two fellow judges to allow a federal death penalty to go forward. This was in July of 2020. So she has apparently resolved that issue, that as an appellate judge, she could behave differently than she would as a trial judge. Now, the last and most interesting question, of course, is as a Supreme Court justice who has at once stated her commitment to stare decisis and also to states' rights, to federalism, to state diversity, but overwhelmingly a devout practicing Catholic, would she find that human dignity, which the United States Supreme Court has used as the basis for determining what the Eighth Amendment is, that human dignity is violated by the death penalty? My guess is that she will act as Ruth Bader Ginsburg would have acted, to strike down the death penalty as unconstitutionally violative of the Eighth Amendment if she's ever given the chance to be that fifth vote. Right now, Ginsburg was one of what I think are 4 votes: Breyer, Ginsburg, Sotomayor, and who am I missing? Of course. She's less certain, but probably Kagan. Probably Kagan. They have 3 reliable votes. They had 3 reliable votes. With Amy Coney Barrett as the United States Supreme Court Justice, abolitionists again will have, or do have, 3 reliable votes, I think, to strike down the death penalty as unconstitutional. So you can oppose her on many grounds, but not that one, the abolitionists. They should feel cheered and heartened by her appointment to the United States Supreme Court, her nomination or confirmation, depending upon when this takes place.
But I wonder, do you think, 2 questions. One is, do you think that the reason she voted the way she did in July of this year was so that she would get nominated to the Supreme Court?
I never even thought of that. That's interesting. I should know more about her record than I know, to see if there are other death penalty cases that she allowed to move forward July of 2020. Well, she's been on the short list of the present administration for a while. Did she have reason? Is it a political? I don't know. I can't answer that. What I can answer is my belief that she is, by conviction and religious belief, an abolitionist. And were she given the opportunity to strike down the death penalty as unconstitutionally violative of the Eighth Amendment, I am convinced she would and will strike it down if she ever has 4 other justices who will do it with her.
Do you think that, given separation of church and state, that she should recuse herself from death penalty rulings?
That's a very difficult question. As a Supreme Court justice, because the Supreme Court is entitled to make the moral decision as to whether the death penalty violates human dignity, and I, of course, believe it does not necessarily violate human dignity at all. I believe that it supports human dignity. But because that is a moral question that can be stated in a secular way, if informed by her religion, she nevertheless comes to the moral decision that it is violative of human dignity and or that evolving standards of decency outlaw it, then it seems to me not unreasonable to say that she can sit in judgment in that way, and that one's moral outlook is a product of many factors, and legitimately one of them is a religion. If she feels bound by her religion to vote that way, because remember, the Catholic Church for many centuries, first of all, many centuries supported the death penalty. Then even recently, but not most recently, was against the death penalty in almost all instances, but still supported the death penalty through the 1980s, 90s, and 2000s, early 2000s. I forgot the crucial year. It may even be within the last couple of years. It still allowed for a death penalty when necessary to restore harmony to the state. Only recently has the present Pope Francis come out and issued an encyclical as absolutely, categorically against the death penalty. If she feels bound by that because the Pope has issued that encyclical, then I think she should recuse herself. If, however, informed by her background, as every Supreme Court justice is, she comes to the moral decision that it violates human dignity, not because the Pope says so, but that the Pope says so because it does, then she seems to me qualified to make that decision and join 4 other justices and strike it down, which I will be appalled if she does do it, but it seems to me she would have the right to do it.
Thank you.
Sure. Thank you. Okay, we're cooked. Thank you, Joe. It's good that we're done because my voice is now shot.
So much. And thanks to your wife.
I will. But
Rolling?
Yes, we are rolling.
Okay.
I do believe if the issue is human dignity, which it should be, that a categorical exemption of the mentally disabled from society's ultimate punishment undermines their humanity and their human dignity. I would rather have them be eligible for it and never get it than have them be categorically ineligible.